Surely by now you've heard that the evil conservative-aligned Supreme Court just ruled to disenfranchise the voting rights of tens of thousands of Wisconsin residents. Of course, nothing could be further from the truth. No Wisconsin residents have had their voting rights infringed by the Supreme Court in this case, or really any other court. Let's talk about what's actually going on. Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota, and today we're talking about the Supreme Court's decision to not extend the deadline for voting in Wisconsin, which is a little bit of it's a misleading sort of premise. In the first place, the Supreme Court of the United States has no place to extend the voting deadline in the state of Wisconsin, and that is kind of the principal reason here. But let's kind of talk about what's been going on, and if you read different places, you'll get different ideas about it. So here's New York Times. It says the Supreme Court won't extend Wisconsin's deadline for mailed ballots, which again is kind of a faulty premise, but it is a premise nonetheless. Here's a different sort of take from Jezebel. The Supreme Court tells Wisconsin voters to fuck off. And while that headline may be funny, it's also not really correct at all. But what, of course, do we expect from Jezebel? And if the answer is anything more than not much, you may need to rethink your positions. Let's go back to the New York Times. We'll take a look at what's going on here and try and suss out what's actually happening. All right, so it says, in April, the court had assumed an extension was permissible. Kind of true, but not really, though it insisted that ballots be mailed and postmarked before Election Day. All right. The Supreme Court refused on Monday to revive a trial court ruling that would have extended Wisconsin's deadline for receiving absentee ballots to 6 days after the election. Now, notice what has happened here. It says that the Supreme Court refuses to extend Wisconsin's deadline, but that wasn't really the question before it. The question before it was whether the appellate court's decision to stay the trial court's ruling was proper. That's actually the question before the Supreme Court. They didn't really get into grand sweeping ideas of the propriety of extending it. And again, the most important thing being, it's not the Supreme Court's job to do this. And we're going to talk about that in just a minute, but let's read on a little bit. Vote was 5-3, with the court's more conservative justices in the majority. As is typical, the court's brief, unsigned order gave no reasons, but several justices filed concurring and dissenting opinions that spanned 35 pages and revealed a stark divide in their understanding of the role of the courts in protecting the right to vote during a pandemic. Now, let's figure this out real quick, okay? The Constitution provides for a way to make voting arrangements, all right? It does, and it's done at the state level by the state legislatures. They create the rules for voting within a particular state, and there's a broad ability to do it, which is kind of interesting because in some ways that means, at least as far as federal elections go, the states may be able to allow some people to vote that wouldn't otherwise be able to vote. And the federal government may not be able to say too much about it. However, there is another provision in there that does say that the federal legislature can make rules about state voting under certain circumstances as well. So it's kind of this dual system, but the overwhelming majority of the voting process is in the autonomy of the state legislature itself. The state legislature makes the rules, the state governor passes those rules into law, and then there you have the voting procedure. So if you want to change it as a result of the COVID or whatever it may be, you have to actually go through that process. And that isn't what happened here. The state legislature in Wisconsin didn't do that. They didn't make an extension. And interestingly, neither did the state courts in Wisconsin. This is This is in the federal Supreme Court, right? So it didn't run through the Wisconsin state courts and have them come in and say, we want a 6-day extension, and then have the federal government come in and say, no, you can't do that. That's not what happened. In fact, this case was brought in district court in Wisconsin, in the federal district court. For some reason, it was brought there, and they requested to extend the voting timeline. Now, the Court of Appeals, which is based in Chicago, the Court of Appeals for that circuit went ahead and said, no, you can't do that. Federal judges can't come in and change state legislatures' election rules. That is an improper, intrusion into the state's autonomy. Now, a state court in Wisconsin may be able to interpret their constitutional principles in a way that would allow that to occur. But again, that's not what happened here. So the district court came in and put in new deadlines. They just some federal judge just decided that Wisconsin would have a longer voting deadline. Because whatever, man. Because they can. And this is a key difference between the Pennsylvania case that's a 4-4 deadlock right now and the Wisconsin case that's going on, is that the Pennsylvania case is coming from the state courts, whereas the Wisconsin case is coming through the federal courts. And so the Wisconsin case, they're saying that the district court in Wisconsin, it's improper for them to step in to the state election in the first place. They don't have the ability to change the rules. So we'll get back to that disenfranchisement thing in a minute, though. So the ruling was considered a victory for Republicans in a crucial swing state, which polls have shown Mr. Trump trailing in after winning by about 23,000 votes in 2016. And I just editorializing this here for a second. I always find this idea hilarious that anything that upholds the rules of elections is seen as a victory for Republicans, and anything that would bend or alter or extend the rules of elections seems to be seen as a victory for Democrats by and large across all states across the nation. And I know it doesn't mean it, but it sure looks like the entire media is complicit with the idea that the Democrats want to bend, break, or change election rules, and Republicans want to follow election rules. It's just a funny sort of narrative. It's not entirely accurate, but it comes across that way. The Democrat Party of Wisconsin immediately announced a voter education project to alert voters that absentee ballots have to be received by 8 p.m. on Election Day, November 3rd. Now, of course, the state of Wisconsin mailed every single voter an absentee ballot. Every single one of them. Did they all get them? I don't know. Probably somebody was missed, but they mailed everybody an absentee ballot. They have early voting available and have for weeks. They have all sorts of ways that people can actually still vote. No one is prevented from voting. And in fact, you can just go in on Election Day and vote as well. Or you can mail your absentee ballot today, tomorrow, the next day. It'll still get there. But that's where we are right now, okay? We're dialing up a huge voter education campaign, Ben Wickler, the state party chairman, said on Twitter. U.S. Postal Service has recommended that voters mail their ballots by October 27th. Oh, that is today, to ensure that they're counted. Yep, and you should. You should mail them by today if you want to vote early by mail. Or you could just vote early in person, or you could do any number of things. Again, they've known forever that this would happen. And the deadlines have not changed. Wisconsin overtly did not change the deadlines. They didn't do it. They could have. They had the opportunity. They chose not to. The ruling came as President Trump continued to attack mail-in voting, which Democrats are using far more heavily this year. In a tweet late Monday, Mr. Trump falsely declared there were big problems and discrepancies with mail-in ballots all over the USA. Must have final total on November 3rd. Twitter quickly put a warning label on the tweet. Why is that a warning label? You have to have the final total on November 3rd, is what he's saying. And courts are largely upholding that at the moment. The ruling was also the latest in a flurry of election year decisions by the court that have mostly upheld voting restrictions. Yes, because, again, state legislatures make the rules, and it's not really proper for the Supreme Court to step in and change them. And the Trump campaign and its Republican allies are seeking similar restrictions on ballot deadlines in other states. Cases from North Carolina and Pennsylvania are pending before the court, the latter a second attempt after a 4-4 deadlock last week. Justice Amy Coney Barrett, who was confirmed on Monday night, could cast the decisive vote in that case. In Monday's opinions, divisions over voting rights that had been hinted at in some of the previous rulings came more clearly into the open. In one concurring opinion, Justice Neil Gorsuch, joined by Justice Brett Kavanaugh, wrote that federal trial judges should not alter state voting rules when an election is looming. They said when an election is looming, but I think they probably also just mean in general. Elections must end sometime. This is a quote from the opinion. A single deadline supplies clear notice, and requiring ballots be in by election day puts all voters on the same footing, Justice Gorsuch wrote. Quote, no one doubts that conducting a national election amid a pandemic poses serious challenges, he wrote, but none of that means individual judges may improvise with their own election rules in place of those the people's representatives have adopted. And this is, of course, the most important point. How you set up election rules is a political question to be decided democratically, not autocratically by a lifetime appointed federal judge. Even state judges in many states are subject to popular election, whereas federal judges are not. And it's improper for a federal judge to impose a rule on a state and just change what their democratically elected representatives determined to be proper. In a separate concurrence, Justice Kavanaugh wrote that, quote, the Constitution principally entrusts politically accountable state legislatures, not unelected federal judges, with the responsibility to address the health and safety of the people during the COVID-19 pandemic. And it's important to remember that the Wisconsin legislature did this. They contemplated the effect of the pandemic. They set aside several ways for people to get voting. They expanded the ability of people to vote. They expanded the timelines for people to vote. They just didn't expand them past election day. They didn't do it past election day. They expanded the window earlier and earlier, making early voting, boosting absentee and mail-in ballots. They did all that. They contemplated this thing. It's not like it just crept up on Wisconsin and now the feds have to step in. It's not what happened. In earlier litigation concerning Wisconsin's primary elections in April, the court required that ballots be mailed and postmarked by Election Day, but it did not disturb a similar 6-day extension for receipt of the ballots, which had not been challenged in the case then before it. And this is a big part of that. It had not been challenged in the case then before it. If it's not challenged, they're not going to mess with it. And why? Well, probably because, very simply, that case, I believe, was about the primaries, and not the ultimate election itself. And there was some flexibility because the primaries are prior to the election. The primary occurs way earlier in the year, and you can have some buffer time. But once the election time comes down, we're in constitutional crunch time, baby. It has to happen. Things have to move. Things have to be counted. Electors have to be picked, and then they have to cast their votes by a constitutionally required time. That needs to occur. And so you have more flexibility earlier in the year with the primary elections than you do with the general election. In dissent on Monday, Justice Elena Kagan, joined by Justices Stephen Breyer and Sonia Sotomayor, 3 brave, beautiful women, said the state's experience in April was telling. The extension of Wisconsin's ballot receipt deadline ensured that COVID-related delays in the delivery and processing of mail ballots would not disenfranchise citizens fearful of voting in person, Justice Kagan wrote. Because of the court's ruling, state officials counted 80,000 ballots, about 5% of the total cast, that were postmarked by Election Day, but would have been discarded for arriving a few days later. Well, it's good that that was earlier in the year and that this is now happening, and things are, again, it's hard to remember that things are very, very different today than they were in April. In fact, our knowledge of the pandemic, how the lockdowns are going, all of that stuff has changed. Lots of delivery and mail services that were slower have picked up. Businesses have some places opened back up. We've got a more firm grasp on actually who's working. These are very different times of year during a very strange year. Chief Justice John Roberts filed a brief concurring opinion explaining why the Wisconsin case differed from the one in Pennsylvania, in which the justices deadlocked over whether the state Supreme Court could extend the deadline for mailed ballots by 3 days, while the Pennsylvania applications implicated the authority of state courts to apply their own constitutions to election regulations. This case involves federal intrusion on state lawmaking processes, the Chief Justice wrote. Different bodies of law and different precedents govern these two situations and require, in these particular circumstances, that we allow the modification of election rules in Pennsylvania, but not Wisconsin. And it's important to know that Chief Justice John Roberts voted with Kagan, Sotomayor, and Breyer in the Pennsylvania case, which is why we have a 4-4 deadlock there. A divided 3-judge panel of the Federal Appeals Court in Chicago had blocked the trial court's ruling. This is where it came from. The Supreme Court didn't actually block the trial court's ruling. They refused to lift the appeals court's block on the trial court's ruling. That's a different thing as well. The Supreme Court didn't come in and say, we need to do this. They said, we will go ahead and leave it with the decision of the appeals court because it's the correct decision. Saying it came too close to the election amounted to judicial interference and a task for the elected branches of government. Supreme Court's order on Monday let the appeals court ruling stand, restoring a hard deadline for accepting absentee ballots to 8 p.m. November 3rd when the polls close. As it should be, because the Wisconsin state legislature decided that, and that is how we decide these things. The state legislature could have changed this. They chose not to. So that's it. We don't need to keep writing or reading on this. Let's be very clear. No one's right to vote has been impacted in any way. Anyone in this election can vote in the way that we vote in every election, which is going in person. Anyone could have already voted at this point. They can still they can mail in absentee ballots today. 10/27 is getting a little bit late on the 27th, but they could have mailed them in by today to sort of ensure delivery. They can still mail them in tomorrow and they'll probably get there. But hey, if you don't think your ballot's going to make it, go in person. Go in and vote early. There are all sorts of opportunities to vote. Go do it. What this doesn't allow is for someone to wait until, until 4 p.m. on election day, postmark their ballot, mail it in, and have it come in, several days after that. You can't do that in Wisconsin this year. I'm sorry. Talk to your state legislature and change who they are if you don't like how they voted on it. All right? That's what's happened. I hope that helps clear things up a little bit. As a summary, the Supreme Court of the United States and really the federal courts in general have no place changing individual states' election rules. Now, if the federal Congress had decided to go ahead and implement a nationwide extension for ballots, which they might be able to do constitutionally, that would be a question for the federal courts to answer. Can they impose these differing rules on the states? And that probably would have come up with a different result, where they would have said, you know what? The federal government does this. It's the federal vote. By extending this, it's not an undue burden on the states. In fact, it adds, they could reasonably come to the conclusion that the federal Congress can do that so long as it's constitutional. What they didn't have happen in this case was any of that. Instead, the state court the state legislature in Wisconsin created a set of rules to deal with the pandemic and the complications that it brings with it in voting. What they did not do in that set of rules was extend the deadline for mail-in ballots to be later than Election Day. They didn't do it. It's not a new rule. It's the rule. They just chose not to change the rule. They changed other rules instead. So since they contemplated it, it is not really proper at all for a federal court to step in and have one unelected judge just decide how many extra days Wisconsin needs to vote. All right. Thanks for watching. Hope you enjoyed it. Hope you learned something. Have a good day. We'll talk soon. Peace. Peace.